Welcome everyone and happy Tuesday. My name is Ellen Berkshire. I am the new president of the Women's Property Tax Association. I want to thank everyone for joining us today for our topic on the Illinois Notary Law changes, which took effect as of January 1, 2022. This broadcast and presentation has been approved by the MCLE for 0.75 hours. So be sure at the end of the presentation that you complete the evaluation form that will either pop up on your screen or be sent to you via email. I also want to encourage everyone to answer any questions or place any questions that they may have in the control panel section of the webinar. You're able to put questions in there at any point in time during the presentation, and we'll get those answered as they come in or at the end of the presentation. And also want to point out to you that within the control panel, there are 4 handouts related to this presentation. They include the PowerPoint slides, as well as the bio of our presenter and the actual laws themselves in PDF form. And so with that, I want to present to you Mr. Kevin Stine. He had prepared an article for the ISBA on the changes to the notary law that we picked up on and reached out to him, and he thankfully agreed to present to the Women's Property Tax Association on this important topic. He is a distinguished attorney who had a career for over 35 years and is now in general counsel for FCB banks. And he's also presented quite a bit for different organizations and has taught classes as well for MBA programs and at a law school. So with that, I will turn it over to Mr. Stine, and thank you again for agreeing to present to this group.
Thank you. I think that's the first and probably last time I will be called a distinguished attorney, but I appreciate that. Just to give everyone, first of all, welcome to everyone, but to give everyone a little bit of context, I am general counsel for FCB Banks. We are a group of banks in Southern Illinois, and when the new statute was passed regarding the changes to the notary laws, we obviously have a lot of employees at the bank that are notaries, and so I was given the task of going through the law, the new changes, and putting together a presentation to the employees of the bank that are notaries regarding these changes, and that's what you're seeing today. I did this originally in December of 2021 because the act was supposed to take effect January 1 of 2022, but the legislature had an out there. They said it's the later of January 1, 2022, or the date that the Illinois Secretary of State promulgates administrative rules to allow this to take place. So we kind of thought what we would tell our employees is to start following these rules January 1, 2022, believing that the Secretary of State would act on that, promulgate the administrative rules, and it would probably be done by summer of 2022. Well, now it's almost March 2023, and the Secretary of State has still not promulgated those administrative rules. So I believe as of today, this is not effective yet, but at least you'll be ahead of the curve and we'll know what's coming when it does become effective. So I just wanted to put that into context for where we are today. I'm going to go over the highlight. I would encourage all of you to read the statute. There's a lot of information there. Again, this presentation that I'm doing was what I prepared to prepare for our notaries at the bank. If you're notarizing a lot of other type of documents instead of at a bank setting, there may be other provisions in the statute that would apply to you that I'm not going to cover today. So read the statute and, sit there with a highlighter like the old days, print it out and highlight it and see what you think applies to you. But these are kind of the highlights. Under the new rule, upon obtaining or renewing a notary, you have to provide an email address to the Illinois Secretary of State. Obviously, this is so the Secretary of State knows how to get a hold of you. If they have any issues regarding your notary, they don't have to worry about mailing anything anymore. It's kind of changing with the times finally, a little slow, but you are required to provide an email address to the Secretary of State. What we told our employees is don't use your bank or your work email address because you may change jobs, you may retire. So we suggested to use a personal email address so that when you do, if you do change jobs or you do retire, you can still receive your notifications from the Secretary of State. If you do want to use your work address, that's fine, but just remember that if you leave that and get a new work email, you're going to have to notify the Secretary of State of that change of address, and a lot of times we forget things like that. You must also, upon obtaining or renewing a notary, take a required notarization course and pass the exam. Again, the Illinois Secretary of State has not prepared that course yet. What I believe is going to happen is the Secretary of State is probably going to have a list of approved vendors that allow you to take that course through an approved vendor online. I'm sure they're going to charge a fee. And if you are a notary now, your notary is still good until you have to renew it. When you renew your notary, that's when you will have to take the new course, assuming the Secretary of State has put that in place at that time. So hopefully, if you have a renewal coming up, it's in the next couple of months before the rules go into effect, and you won't have to worry about taking the course, at least for the first renewal. Upon obtaining or renewing your notary, you're required to get the notary commission through the Illinois Secretary of State. You have to, or not through them, but an approved vendor. You must obtain your official seal or stamp. That's not really new, but that's just something to keep in mind. I know I've seen situations at our bank where somebody renews their notary, but they keep using the old stamp. And obviously that creates issues since the stamp itself has the expiration date on it. And as I tell our notaries at the bank, like many of you, they notarize a lot of documents. And it almost becomes just a sign and stamp, and almost like rote. You don't really think about it. And you don't realize that the reason that you're notarizing something is to help prevent fraud or to make something official. And little mistakes cause problems later. You may have a totally valid deed, but if you accidentally use a seal that is expired, even though your commission was renewed timely, that just creates issues for lawyers to latch on to that want to attack that deed, even though it's official. Lawyers, we call them talking points. It doesn't really matter how good or bad your case is. The more talking points you have, the more leverage you have to resolve your case. And don't let your act of negligence or carelessness be a talking point in the case. Take your job as a notary seriously. Take your time. Make sure you do it right. The notary commission is no longer required to be recorded with the county clerk. For those of you that have been notaries, you realize that when you get your notary or you renew your notary, you're sent a written commission that you're required to take up to the county clerk and record it. You don't have to do that anymore. Now, once you complete your renewal online with the Secretary of State, you're done. Nothing needs to be recorded. So that's some good news. The Illinois Secretary of State must be notified of any residential address or email address change within 30 days. If you move, notify the Secretary of State on the website within 30 days. If you change your email, either because you used a work email or maybe you just change your personal email address, you are required to notify the Secretary of State within 30 days of any of those changes. And another change that is I think pretty significant, or at least it was for us, is that a notary cannot explain, certify, or verify the contents of any document. This was a big problem for us because what we would do is have loan officers that were notaries, and as a convenience to our customers, if we needed a mortgage signed, the loan officer would print out the loan documents, drive out to the house or the place of business of the customer, present the loan documents to the customer, and then have the customer sign the mortgage, and then the loan officer would notarize the mortgage. Nothing wrong with that, unless there's a question about the document. And there are questions. They may take the document out to a customer, and the mortgage may have a waiver of right of redemption in it. And the customer may go through and say, what is this waiver of right of redemption? And the loan officer will say, well, that's something that we require in all of our commercial mortgages. It basically takes the foreclosure period down from a 1-year period to about a 4-month period. And if you want a loan from us, we require that that's in there. Well, they can't do that anymore. Whoever notarizes the document cannot explain or certify or verify anything in that document. Your sole role is to notarize the signature, nothing else. So now we're at a situation where in our situation, if a loan officer does take the documents out there and there are any questions about the mortgage that they're notarizing, the loan officer has to say, well, I can't explain that to you. Let me go. We're going to have to schedule this for a different day. And then he or she has to bring a notary with him to do the notary while the loan officer explains the document. So keep that in mind. We all want to be helpful all the time, but don't explain it. And the other context I see this coming into is you notarize things for friends or family, and they know you work maybe in a law office or at a title company, and they'll say, what does this mean? You should not explain that to them. I know it's going to be hard not to, but I think you just need to explain to them, listen, my role, I'm an officer of the state of Illinois as a notary. A statute says I cannot explain this to you, and if I do, I'm guilty of a criminal act. I can't do that. If you want that explained, go back to the person that prepared the document or seek advice of an attorney. And I know that sounds harsh, and I'm also realistic to know that some of this is probably going to go on. My job is to tell you not to do it. The biggest change, at least from our standpoint, is Illinois notaries must now keep a journal. I've been a notary for about 35 years. I've never kept a journal. I've never kept a list of anything I've notarized. I start keeping one now because I know it's going to be required. The journal can be paper or electronic, or it can be a combination, but you have to keep a journal that has all the requirements. Our bank bought journals for our employees and issued them to the employees because we want everybody, we've requested that everybody use the journal we provide. We can't force them to do that, but we've asked them to do that just so we have some consistency in how we keep track of things. The key to the journal is it's like your notary stamp. It's yours. It's not your employer's. Even though your employer buys your journal, it's not the employer's journal. It is your personal journal. If you leave employment, you take that journal with you. You don't leave it with the employer. Just like your notary stamp. You keep your notary stamp with you. The employer doesn't keep your notary stamp. If the journal is lost or stolen or compromised, you're required by the statute to notify the Illinois Secretary of State within 10 business days after you discover that. So if you lose your journal and you can't find it, within the 10 days, you better notify the Secretary of State. And what will usually happen is you'll find the journal 2 days later. That's fine. Notify the Secretary of State that you've now found it. If your journal has been compromised, that would be a situation where, let's suppose that you take your journal to the courthouse because you're going to notarize something there. You leave it laying on the bench. 5 days later, you get a call from the courthouse saying that somebody turned in your notary journal. At that point, your notary journal has been compromised. It's been out there in the public. And the safe side would be contact the Secretary of State, explain to them what happened. That way you're good from the Secretary of State standpoint. It doesn't necessarily mean that somebody did anything nefarious and copied it or used any information in it, but it has been compromised in the sense that it has been out there in the public. And I think you'd be required, or at least advised at that point, to let the Secretary of State know that what happened, so that if an issue comes up later, you're protected. You cannot provide any information in the journal to a third party, and especially personally identifiable information, except when required by law. You can provide it to law enforcement, you can provide it to the Illinois Secretary of State, or you can provide it pursuant to a court order. There is an exception to that. If you receive a written request, and that's the key, a written request from a third party, that includes, and that request must include the names of the parties, the type of document, the month and year that the record was notarized, then you can supply a copy from your journal of that line item and that transaction after redacting personally identifying information. The reason for this is somebody's not on a fishing expedition. Maybe somebody, dad died and they're going through dad's documents and there's a deed in there where dad transferred 80 acres of farm ground to his son. Somebody may want to verify that that was a valid deed and that it was properly notarized. So if they go to you and say, hey, you were listed as the notary on this deed dated December 2003 from Kevin Stine to Justin Stine, I would like to see if that's in your journal to verify this was properly notarized. You can then give them that. Just make sure you redact personal information, such as if you have a driver's license number down, if you have a date of birth down, if you have an address down, just redact any of that out of there. And then you can provide them just that one line. Don't make a copy of your journal page. Just the line from that journal is what you provide to them. If somebody calls you on the phone and says, hey, I think my dad, Kevin Stine, gave a deed to my brother a few years ago. Can you look at your journal and verify that? You can't do that. You're providing them information. You can't do that. They have to provide to you a written request with the information listed, all the information listed, or just tell them without that, you cannot provide any information without a court order. You must keep your journal for 5 years after termination of your registration as a notary. That's important. If you retire and let's suppose you retire in 2008, you still keep, you may think, well, if I retired in 2008, I can keep my journal till 2013. That's not true. Your notary commission may not have terminated until 2011. If that's the case, you have to keep your journal to 2016. It's 5 years from when your notary registration terminates, not 5 years from when you quit notarizing documents. Okay. What is required to be contained in the journal? The first one is the date of the Notary Act, and obviously this date should match the date that you sign on the notary seal. The type, title, or some description of the document being notarized. If it's an affidavit, if it's a deed, if it's a mortgage, if it's a will, whatever you're notarizing, make sure you describe it with particular description. Don't just write down document or transfer. Describe the document that you're actually notarizing. The more information you have, the better. If the document involves real estate, you must put the property index number used to identify the property for tax purposes, and also the common address of the property that's subject to the deed of conveyance. So that would include deeds, mortgages, anything having to do with real estate. You must put the PIN number and the common address of the property. Okay. You'll need to put the printed name and the resident street address of each person whose signature you're notarizing. Has to be printed clear. Okay. a description of the evidence you reviewed to determine the identity of the person whose signature you are notarizing. If they give you a driver's license, I would put down Illinois driver's license number blank, expiration date blank. The reason I would put all that information down is, number one, it gives you, it verifies that you in fact did look at a driver's license, number one. And number two, looking at the driver's license for the expiration date, again, shows that you looked at the driver's license and shows that it was not expired at the time you looked at it.
Kevin, we do have a quick question here, and that
Sure.
relates to the 5-year rule that you were talking about. And the question is, what if you terminate your notary early?
Then, yeah, once your notary is terminated, that's when the 5 years starts to run.
Okay.
That's
Thank
a good
you.
question. But yeah, you can, yeah, if you retire and you say, I'm not going to be a notary anymore, you can contact the Secretary of State, terminate your commission as a notary, and once that's terminated, your 5 years starts rolling at that point. Okay. On the journal that we used, we told our people, make sure that each entry is completely filled out immediately after the document is notarized. And actually, I even suggested before it's notarized. And part of the reason is on our documents, we required the printed name of the individual and the signature of the individual. And the problem is, if you wait until after you notarize it, the person may be gone and not there to sign anymore. You know, everybody's always in a hurry. They sign their deed, they hand it to you to notarize it, they leave, you then go to fill in your journal and you realize, shoot, I forgot to get their signature, or I forgot to write down the driver's license number. So I would encourage you, if at all possible, to actually fill in your notary journal immediately prior to actually notarizing the document. And that way, you know, your journal is filled out prior to you finally notarizing the document. We don't do any work in Cook County, so we were not required to obtain fingerprints, even though our journal has a place for the fingerprints. But I do know that Cook County residential real estate documents do require a thumbprint but I think that is already in place for those of you that do work in Cook County. If you're notarizing residential documents, you will still need to get that thumbprint, despite what my presentation says today. So I did want to point that out. I didn't want to lead you Cook County notaries under the false belief that you don't have to do that anymore.
We do have another question sort of related to that, and that is that someone is asking if 99% of the documents that they're notarizing end up submitted to a public body and are discoverable via FOIA, like affidavits and that type of things, do they still have to keep a journal?
Yes.
Okay.
Yes. And that was, and at least that's what I believe. I know we have a situation in our bank where we have one person that does all of our releases of mortgages, prepares all our release of mortgages, which is, you know, thousands probably a year. And they said, and there are only like 4 people in the bank that are authorized to sign those releases of mortgage. And they said, so do I really have to do a separate journal entry for each one of those? And I said, yes, you do. Now you can use, if you're doing 8 of them in a row, you can use the ditto marks if you want to, but you need a separate line for each document that you're notarizing, because each document's going to have a separate residential address. Each document's going to have a separate description, because hopefully you're going to say, and each document's going to have a separate PIN number. So it creates a lot more work, and it's frustrating. The other thing that came out of it is, and they said, do I really have to see them sign the document? I said, you have to see them sign it, or you have to have them tell you in person that they acknowledge that they signed it. And they said, well, that's not really practical. I said, it's going to have to become practical. You said you should have been doing that before. I know my secretary, I had the same secretary for 15 years, and I needed something notarized by my wife. And my secretary says, you know, I've seen your wife's signature 100 times. Just tell her to call me and tell her it's her signature. I said, no. She says, I know her. I know her signature. I said, I'm not doing that because I want you to be able to testify under oath that you have never, ever notarized the signature without being face-to-face with that person and that person signing it in front of you, or that person acknowledging to you face-to-face that that is their signature. Because once you start down that slippery slope, again, it creates talking points. Have you ever notarized the signature without seeing the person sign or having them acknowledge it in front of you? Well, sometimes I do if I know the person. Well, that all of a sudden creates an issue of doubt. So you're better off following the rules and being able to give veracity to all of your notarial signatures instead of just some of them. Okay. Acceptable forms of ID. Believe it or not, this comes up a lot more than you may think in our bank situation. What we accept is a state-issued driver's license. Again, we require it to be current. We don't accept a expired driver's license. A state-issued identification card, a U.S. passport, or a U.S. military ID. Let's suppose you need, and this has come up, what if you need to notarize the signature of a 12-year-old kid or a 15-year-old kid, which you may have to do sometime. They aren't going to have a driver's license. They may have a passport. They may not. They aren't going to have a military ID. At that point, what you're going to have to do is have something, and you have to decide what's good for you. But I would suggest to require them to get a state-issued identification card. Again, it's how much risk you want to take, but that's what I have told our people they need to do. It doesn't come up a lot with a minor, but it could come up a lot with somebody. Maybe an older individual that hasn't driven for 10 years. They may not have a current driver's license. And if you're comfortable relying on an old driver's license, I'll leave that up to you. But again, it just creates issues. Do not leave blanks on the document. This is one of my pet peeves, and believe it or not, I see it a lot. People are in a hurry. And what they do is they fill out, like this is on the slide, County of Los Angeles. I can't tell you how many times that's left blank. Doesn't sound like a big deal, but again, it's one of those things that can be used to create doubt or create issues. Take your time when you're filling out your notary portion of the document. Make sure it's right. Make sure names are spelled right. Make sure the name that's in the blank is the name that you're notarizing. Make sure the date's correct. And then sign your name the same as your notary stamp. The other thing that's an example is we sometimes get documents from out of state. And it's okay to notarize a document that's prepared in California. The key is you have to be in the state of Illinois, and the person you're notarizing has to be in the state of Illinois at the time you're notarizing. The problem becomes when there's a pre-printed document. If there's a pre-printed document that says state of California, what you simply do is mark through California, write in Illinois, and initial it. Same thing if the county's wrong. And it's the county that you are sitting in. That's the county you put in there. If your notarial seal is from Cook County, because that's where you reside, but you are notarizing something in Sangamon County, if you're located in Sangamon County when the notary is taking place, it's state of Illinois, county of Sangamon. It's not the county where your notary was issued. It's the county where you're physically located. But don't leave blanks in this document, and don't notarize a document that has blanks. Look over. You're not required to know what's in the document. In fact, a lot of the documents are personal. But peruse the document you're notarizing, and if there's a blank in there, I think you need to tell the person that you're notarizing the document for, listen, I don't feel comfortable notarizing this when there's a blank. It can lead to fraud. If that's not applicable, put N/, you don't do it. You tell the person you're notarizing, put N/A in there, or if you think that line needs to be filled in, you can either decide what needs to be in there, or you can ask your attorney what needs to be in there. But I do not feel comfortable notarizing a document that has blanks in it. Again, that's up to you. I wouldn't notarize a document that has blanks in it.
Okay,
If there's a
there's
blank,
kind of a question related to that. What if it's a real estate document without the parcel index number on it? Is there any requirement to do research to confirm the index number?
well, you're going to need to put the parcel number on you're required to put the parcel number on your notary, in your notary journal. I don't think you have to independently verify that the parcel number matches the legal description, but I think I would require any real estate document that I'm notarizing, I would just simply say, I need to have, as part of the document, the common address and the parcel number, because I'm required to report that in my journal. So I wouldn't notarize a real estate document that does not contain the parcel number and the common address.
Okay.
Did that answer your question?
I think so. If the person has a follow-up, they can type it in here.
Okay. Violations. This is what we used to hopefully scare our people. I think it worked for a week. You can be sued personally for money damages if you violate the statute. You can also be criminally liable. If it's a willful violation, that's a Class A misdemeanor, which is up to 364 days in jail and up to a fine of $2,500. That's against you. If it's reckless, that's a Class B misdemeanor, up to 180 days in jail, up to a fine of $1,500. These are penalties per violation. Perfect example of this is you work for let's suppose you work for a brokerage company and you've worked for the same boss for 15 years, and the boss brings you in a bunch of powers of attorney that his customers have signed, appointing him as his agent to deal with their accounts. And he brings you in and he said, I need you to notarize these 15 powers of attorney for our clients because I went out and got them signed, but they need to be notarized. Go ahead and notarize them. If you notarize those signatures without either seeing them signed by the individuals, or if they're acknowledgments, by having them in person, face-to-face acknowledge to you that that is their signature, you have violated the statute. And in my mind, you willfully violated the statute. The fact that you did it so many times, you willfully violated the statute. And if your boss uses that power of attorney to take the money out of those accounts and steal from those people, believe me, I think you're going to be probably pursued criminally. I guarantee you will be sued civilly, $2,500 for each one. And there's going to be a lot of pressure to probably have you serve some jail time, because that would be a willful misdemeanor. You're going to have a lot of angry people out there that you notarized their signature that was in fact not their signature. Same can be true of situations where dad's in the nursing home, family farm, brother prepares a deed off the internet, takes it to dad, giving him the farm to the exclusion of his other brothers and sisters. He then brings it to you. He's a family friend and say, hey, dad's in the nursing home. We need to get this taken care of before dad dies. Will you notarize my dad's signature for me? You know my dad. And you notarize it without seeing dad sign it or having dad acknowledge it. Again, I think that's a willful violation. You may be able to argue that once is not willful, but it's going to be reckless at least. So whether you're liable for half a year in jail or a year in jail up to, I mean, realistically, that's probably not going to happen for a one-time thing, but you probably are going to be liable for the fine. Keep these in mind. When you're doing favors for people or your boss that you have a great personal and business relationship with, don't be afraid to tell them, listen, as a notary, I'm an officer of the state. I'm required to follow certain rules, and I'm sorry, but I have to see them sign this, or they have to acknowledge to me that they signed it. Don't be afraid to stand hard on that, because in the end, you're on the hook if you don't follow the rules. Okay, remote notarial acts. remote ink notarizations. These became important because of COVID. People weren't meeting face-to-face anymore, and so there had to be a way to notarize documents. I want to explain the difference. What I'm covering here are remote notarial acts that occur in the state of Illinois. There are also ways that you can be appointed a notary to notarize somebody that's in Florida. That's not what we're talking about here. That's a whole different animal that I'm not going to go into. But these are remote notarial acts. And this part of the statute just provides standards for performing remote notarizations, okay? Any notary commissioned in Illinois can perform a remote notarization. But it does require audio-video communication that allows for direct interaction between the notary and the person signing the document, and it requires it to be recorded. So you have to make sure you're set up for that before you can do a remote. You can't do a remote notarial act by talking on the phone. You can do it on a Zoom call if you can record it, or you can, if you have a way to record your phone with a FaceTime, I guess you could do it that way. But you've got to make sure that you can interact with the person signing and that you can comply with all these rules in order to get that done. It requires the person signing to state as part of the recorded video and audio that they are physically located in Illinois. And I would also tell them to identify the city and county that they're in. So I am in Belleville, St. Clair County, Illinois when I'm signing this document. Okay. It requires them to also state what document they're signing. I am signing a mortgage on 123 Main Street in favor of FCB Banks. It requires each page of the document that you're notarizing to be shown to the person signing, and you need to be able to see that that person can see each page. So you don't just show the document, but you show the person looking at the page and then the person initialing the page. All this has to be visible on the camera, okay? You can't just see his hand initialing a page and then going on. You have to see his face looking at the document, see his hand initialing the document, and you have to do that for each page, okay? It requires the act of signing, the signature, to be captured significantly up close so that you can observe him signing the document and see that it is him signing that signature. So it's not a situation where he's pretending to sign it and then later on they take it to Uncle Bob and Uncle Bob signs it. So there's a lot of things that are required here. If you ever do any of these, I would suggest that you do a practice run with people first. And don't be afraid if you don't think it's captured correctly to stop and say, wait, I got to make sure I can see this. You need to move the camera a little, but make sure you do it right. And it's going to take some practice to get that done. After this is all done, after you get the person identifying who they are, where they are, what document they're signing, after you can see them initial each page of the document, you can see that there are no blanks in there. And then after you see them sign the document at the end, then at that point, they are required no later than the end of the next day to either fax or somehow electronically send that document to you. So if you have this communication this morning at 10 o'clock, by the end of the day tomorrow, you need that document somehow in your possession with their signature on it and all their initials on it, okay? After you receive that, it then requires you to sign the document as the notary and then transmit it back to them with your signature and your notary stamp within 24 hours after you receive it. So if it's signed at 11 or 10 o'clock today, and they send it to you at 11 o'clock today, you have until 10:59 tomorrow to notarize it and complete the notary portion of that and send it back to them. Okay. If necessary, it does permit you to sign the original document and date it the original date of execution, as long as you get it back within 30 days from the date of the remote notarization. This is just important because, like, some lenders, they won't accept electronic forms of documents. They require wet signatures all the way around. So they require the person signing the mortgage to have a wet signature, and they require the notary to have the wet signature. So if we do that, then what happens is your notary, you go through the whole remote process where they sign it, send it to you by the next day. You then notarize it, send it back to them within 24 hours. But if they need a wet signature, what they will do is they will send you the actual original document with their wet signature. They will send it to you, hopefully overnight mail, return receipt. You will then get it a day or two later. You'll then fill out your wet signature notary on that document. And at that point, you are allowed to backdate it to the date of the remote notarization. And then you will then send that original document with all the wet signatures back to them. You can do all this as long as it's within 30 days from the date of the remote notarization. 45 days after that, you can no longer do this. If they ask you to do it, you can just say, no, I can't provide a wet signature anymore. It's past the 30-day period. Okay, I have a couple more things I want to go over besides the slideshow, unless there are more questions, or unless we're out of time. I see it's about 1:45. Do we have time for some other things? Or
there are a few questions.
Okay, let me take those first.
Okay. This question came up a couple times, wanting to know with respect to the journaling, is there a distinction between notarizing a conveyance of a property and just a regular affidavit, or do you have to log everything in the journal?
You log everything that you notarize in the journal. The difference is, obviously, with an affidavit, there's no PIN number and there's no thumbprint required. There's no common address of the real estate. But anytime you use your notary stamp, it gets entered in the journal, not just for real estate.
And are there any penalties for not keeping the journal?
Yeah, it's a violation of the statute. If it's willful, if it's, up to a year in jail and $2,500 per entry. So if you're notified, 10 things, it's $25,000, up to $25,000.
We got a couple more coming in. Some of the items being discussed today are already in effect with the state of Illinois, i.e.
Yeah.
no longer being required to be recorded with the county clerk. Which of the items being discussed are in effect and which are still pending? The journaling is still pending, right?
Journaling's pending. I think the whole statute is pending until the Secretary of State issues their rule.
Right. But what we're recommending is that if you're holding a notary, go ahead and start these requirements now because it's coming.
That's what we required all of our employees to start January 1 of 2022. Even though it's been a year, it's still not in effect. Probably all want to shoot me right now, but it's good to get in practice and nothing else.
Yeah. Couple more questions. Do you need to be an Illinois resident to be a notary if employed in Illinois, but you live outside of the state?
No, you can be an Illinois notary if you live out of state, if you're employed in the state, but I think it's a supplemental application you have to do.
Okay. I'm not sure I understand that question, so I'm not going to ask it. Is Cook County requiring for sales transactions only, or do we need for property tax appeals too? I think we've already answered that, and you have to journal for everything.
Journal for everything, yes. The thumbprint is only for residential real estate transfers.
And someone mentioned that they thought that might have expired, but I'm not seeing that in the statute.
They may be right because I don't do any work in Cook County. They may be correct.
And then one last question, this came up early in the presentation. What happens if you moved and it has been over 30 days for an address change? Just notify as soon as.
Better late than never. Still notify them.
Okay. That's all the questions I believe that we have now. Oh, no, one
Okay.
more. If a driver's license or other form of identification is presented, should you ever keep a photocopy of it in your journal, in your notary journal?
I mean, that's up to you. I probably wouldn't, because here's the problem. Unless, I mean, what I tell our people, be consistent. So if sometimes you keep it, sometimes you don't, and it turns out you get one that you don't have, and that becomes an issue, people, it's just something else to talk about. Why did you keep a copy of the transaction and this transaction?
Okay, no other questions, but I think you had something else to add, right, Kevin?
Yeah, do I have time? Are we good?
Yes.
Okay. Yeah, I just want a couple other things issues that I had. One was, and I think I went over it a little bit, but don't let your boss browbeat you into notarizing something that you know you shouldn't be notarizing. I don't care if it's his wife, mom, and his mom's in the nursing home. You just need to be hard and fast and say, listen, I'm doing this for the protection of the company as well as for my protection. I'm required to see the person notarized or sign it. The other thing, and I know this sounds funny, but know the difference between an acknowledgement and a verification. Read the notary jurat at the end. If you're simply acknowledging a signature, then that's okay. Just have either see the person sign or have them acknowledge it's their signature. If it says after first being sworn under oath, then you are required to give an oath to that person before he signs. Say, do you swear that the document you're about to sign is the truth and nothing but the truth, and have them sign it? If it says that, legally you're required to give them the oath before you can notarize. I know that sounds strange, but that is the case. If the jurat is not in the form that you feel is correct, for instance, the situation before, state of California, change it. Don't notarize something that doesn't look correct. If you're doing, this is a big one, if you're doing a remote notary, the jurat may say, appeared before me in person. I would scratch through that and put appeared before me remotely. Anytime you scratch through something, though, make sure you initial it. Initial each change that you make. Make sure I covered everything. Make sure you complete your notary journals. Like I say, I would encourage you to do it before you actually sign the notary document, so you know you have everything. There's nothing worse than doing this, having the person leave, and you saw their driver's license, but you forgot to write the driver's license number down, or you forgot to write the expiration date down, and you're trying to track that person down. And once they've closed their deal, they aren't going to be probably too excited about getting you information. So until you actually notarize the document, you hold a lot of the cards. So get all that information when you can. And I know a lot of people will be tempted to say, I'll fill out my journal later. I mean, it's like I used to tell all the attorneys, for billing purposes, when you're keeping time records, do a time entry at the time you do the task. Don't try and do it at the end of the day or at the end of the week, because it just creates issues of reliability, and you may not have all the information you need. Take your time. I mean, I'm guilty of it too. Notarize a document, sign your name, and you stamp it. You don't even read the jurat. A lot of times, lawyers are a lot of cut and paste lawyers. There are a lot of cut and paste lawyers. So they may have Kevin Stine in the name of the mortgage, but the jurat may have Sam Smith because they didn't change that. Well, that's going to be on you as the notary, because you are notarizing that. Read the jurat. Read the portion that you are notarizing and make sure it makes sense and make sure it's accurate. Again, don't explain a document to somebody. I know you're tempted to do that. We all want to help. Let's suppose that somebody prints out something off the internet, and I see this a lot now, and it's completely filled out. There's no blanks on it, and they need you to notarize their signature. And you're looking at this, your document, and you've been doing this enough that you know this is wrong. This document does not do what they want it to do. Don't be tempted to tell them it's wrong. Your job as a notary is to verify they are who they are, verify that they are the one signing this document, and get the information for your journal. That's your job. It's not to explain to them that you think they used the wrong form to accomplish what they want to accomplish. That's going to get you in trouble. Even worse is maybe they did have a lawyer prepare it. He or she didn't know what they were doing, but now you're telling them that. They go back to the lawyer and say, well, my notary said that this wasn't right. So you're better off just doing your job as a notary and keeping it at that. If there are no other questions, I think I'm finished.
Okay, I don't see any other questions coming through. I'll give it a minute, but just a reminder to everyone that if you want the CLE credit, you need to have been logged on under your own name and registration and complete the survey at the end of the presentation. And I do not have any other questions, so I do want to thank you very much, Kevin. That was really, really informative and helpful. A lot of changes, and just a last minute reminder, even though these aren't in effect yet, go ahead and get started on these new rules so that you get used to them when they do go into effect. And again, thank you.
And read the statute. Just read it once, please.
Yep, it's in there. It's in the control panel.
Give me a handout.
Yep. Thanks again,
Okay.
everyone. Bye.
Thank you.